Hello and welcome to Freedom Watch, your daily dose of raw liberty online at foxnews.com/freedomwatch. I'm Judge Andrew Napolitano here, defending freedom, defending your natural rights, and defending your right to have a government that stays within the confines of the Constitution. Even if you approve of the U.S. government detaining suspected terrorists at Guantanamo Bay for years without charges filed or trials held, you may be disturbed to learn that heavy restrictions are placed on the press who report on the military tribunals that are used at Guantanamo instead of civilian trials there. Reporters from the Miami Herald and 3 Canadian news organizations have been barred from further direct reporting on Guantanamo military commissions because they published the name of a witness in the proceedings, a witness who had been referred to at the hearings only as Interrogator Number 1. Naming that witness violated the ground rules that the reporters had to agree to in order to observe the Guantanamo proceedings. Here's the catch, though. The witness, Joshua Klaus, that's his name, who had previously been convicted by a military court himself for prisoner abuse, had already been named earlier in reports. His name was actually revealed in an open courtroom by a military judge at Guantanamo Bay. No matter, says the military. The Miami Herald reporter and the Canadian reporters observing the tribunals still broke the military ground rules they agreed to and are now banned from Gitmo. Planning to fight the ban is reporter Michelle Shepard of the Toronto Star. Michelle, thank you for joining us on Freedom Watch.
Thanks very much for having me.
So does freedom of the press stop at the military courthouse door?
That trip was my 21st trip to Guantanamo, and all I can say is reporting from there is unlike reporting from any other court hearing that I've been at, reporting almost anywhere. There are rules that are placed on us, and they do seem to be changing over the years.
All right, give us an example of some of the rules that are placed on you before you can go into a military courtroom that have never been imposed upon you in your years of reporting elsewhere.
Well, when we're talking about the ban in this case, it's important to remember that it wasn't the military judge or the military commissions that found us in violation of this protective order that shielded the identity of the interrogator. It was the ground rules of the Pentagon. And these are largely administrative rules that are set by the Office of Secretary of Defense. And they set out what we can and can't do. But the bottom line is we have to sign those papers to go to Guantanamo. If we don't sign them, we can't go into the courtroom.
All right, if you were a reporter in my courtroom back in New Jersey when I was trying cases, and you revealed some sort of a secret and one of the parties moved to exclude you, you would have a right to a hearing before me. Or if you felt that I couldn't give you a fair hearing because it was my order that you allegedly violated, you'd get a hearing before another judge. Do you have the opportunity for a hearing before any truly neutral party here in order to reobtain your press credentials to go back into the military courtroom?
No, and it's an excellent point, because the issue of having these protective orders is not what we're challenging in itself. There is a need for these orders for some of the witnesses that will come forward, some military officers that might be redeployed, those witnesses that worry about the safety of their family. But the issue is that it was a blanket order, and in fact, we were opposed to this one interrogator, since besides the fact that he had already been named in a court-martial, I personally had an interview with him on the record 2 years ago in which he gave me his name and wanted it in the newspaper. So we actually sent a note to the judge in this case saying, could we make submissions on this? We don't have a lawyer in Guantanamo, but we were prepared to do that ourselves and make a submission, argue our case. We weren't heard. And now the ban is in place, and we've appealed to the very body the Office of the Secretary of Defense, Public Affairs Officer, that issued the ban.
I have a lot of problems with these tribunals. You know, the judge and the prosecutor have the same boss, the Secretary of Defense. The Secretary of Defense, under the law in covering these tribunals, can change the judge if he doesn't like the rulings. The president can incarcerate somebody after they're found not guilty, a procedure that even the dictators in Europe never claimed that they could do in the last century. Put aside my own views. What have you observed in these courtrooms about American military justice in Guantanamo Bay that the public should know about?
Well, I think there's still some problems. Probably the one that was highlighted to us by the critics and defense lawyers on this last hearing was the fact that the process has been amended under the Obama administration, but the rules governing the new military commissions actually weren't finished until the eve of the trial for the Canadian detainee Omar Khadr. The fact that the rule book was only given the night before, I think when we're in 2010 and Guantanamo Bay opened in 2002, is probably problematic.
Michelle Shepard, good luck. I hope that this appeal works. I don't expect it to, but I hope it does. And thanks for sharing this story with us on Freedom Watch.
Well, thank you. I'm a bit more optimistic, but thanks for having me.
You're welcome.